October 10th, 2023, 3:36 a.m. This is how the Swiss kidnapped my family. My response to the OHCHR, Office of High Commissioner for Human Rights. Here goes.
Dear OHCHR agent, it seems that after I proved the admissibility criteria of my responses of October 2021 and May 23, 2022, we are now revisiting the criteria in June 2023 along with an additional attack on my parental authority and character targeted at diminishing my claims of injustice and state-aided child abuse rather than merits of law or the safety of the child. As the FOJ has revisited the partial history of this case, I'm now obligated to include the missing part of the history. Allow me to once again prove admissibility criteria, my parental authority, Swiss falsification of facts, omission of evidence, denial of right to be heard, child neglect, custodial drug parent, the mother's disrespect for her parental duties, perjury by the opposing party, and by the state parties, favoritism, discrimination, prejudicial decision, racism of all the Swiss people doing everything possible to keep apart the Indian father and daughter. However, the history, validity of the first marriage, Swiss breaches of international laws, and documents that prove I have as much right to custody as the mother, also proves that Switzerland has never had jurisdiction over Cassandra Amina Prasad in the first place. Nevertheless, there are no remedies for domestic weaponized government engaging in corruption and concealment. We all know Switzerland is the child trafficking headquarters for the elites that couldn't care any lesser for best interests of children. The Swiss falsified facts to initiate separation proceedings. Divorce is invalid due to erroneous conclusion. The civil case file indeed states, the author of the communication, DP, married LJ in 2014. It should have said, the author of the communication, DP, married LJ in 2014 in the United States, which is easily proved in the civil case files. Cassandra was conceived the third week of November 2015 in the United States. A round-trip, return flight, plane ticket was booked since September 2015 for LJ to take a short vacation to visit family in Switzerland that departed the USA on December 4, 2015, and was scheduled to return on February 14, 2016. I remained in the USA awaiting the return of my wife from vacation. On December 20, 2015, LJ told me over the phone that her doctor, Dr. Rhea Hermanjard, informed her that she was 4 to 5 weeks pregnant, and she was also having family conflict and had no place to stay. I booked her a hotel days before Christmas 2015, and with her desire to return to the USA, I attempted to book an immediate return flight for LJ, but it was blocked by the airlines. On December 23, 2015, our American immigration attorney, Stephanie Ramos, told us why the flight booking was blocked, that LJ was not supposed to leave the USA while she had begun, since early 2015, filings for permanent residency in the USA with the United States Citizenship and Immigration Services, USCIS. Ms. Ramos informed us that LJ was barred by U.S. Homeland Security from returning to the USA, and new filings for spouse visa would have to begin in January 2016 after the holidays. We were told that the process would take about 18 months, but it lasted 24 months due to delays in accumulating required Swiss documents. See Exhibit 1, X1 September 2, 2014 Washington State marriage certificate issued on February 2, 2018. Note that LJ had filed for divorce in Switzerland since March 2017. CX2, February 29, 2016 USCIS confirmation letter referring to LJ by her married name, Layla Prasad, establishing that USCIS and Homeland Security received her communications to initiate immigration filings. I first visited Switzerland from February 12 to 22, 2016 to spend Valentine's Day with my pregnant wife and acquire an apartment for the remainder of the USCIS filings for spouse visa. The civil case file states, as regards the right of physical access, it is apparent from the documents before the court that a first right of access took place in August 2018, which is false. While the USCIS filings were taking so many months, I was in Switzerland taking care of my daughter day and night from August 2, 2016 to October 4, 2016 for the first 2 months of KP Life, December 30, 2016 to February 27, 2017, May 9, 2017 to May 31, 2017. I was taking care of my family by all means, and by living in between the USA and Switzerland for months at a time, I just couldn't stay away from my precious baby girl. Our dog and cat, Lucy and Charlie, were brought to Switzerland temporarily to bond with Cassandra while I was also spending most of my time in Switzerland. CX3, U.S. passport with Border Patrol stamps that prove the dates mentioned. Until December 2017, I discovered that my wife began divorce fraud and swindle, 18 U.S.C. 1341, and immigration fraud, 18 U.S.C. 1546, 9 months prior. In March 2017, Layla Jaksic in Switzerland as a single mother filing for divorce, and loving wife Layla Prasad returning with Cassandra to the USA. Cassandra Amina Prasad being born to a U.S. citizen in wedlock automatically made her a U.S. citizen, and all her rights as a U.S. citizen were established over a year prior to unlawful provisional measures were taken by any Swiss judge, Fribourg Justice of Peace that did not follow procedural law, nor international protocols, by not providing any notice of separation/divorce, but denied my right to contest the divorce and custody decision, having never provided said notice to me of initial civil proceedings. Despite the mother was falsely claiming that she did not know the whereabouts of the father in the USA, the court failed to follow international protocols of mutual assistance in civil matters treaty, and never once contacted the Swiss Central Authority for legal service abroad. My exercise of custody rights began at 7 a.m. August 16, 2016 when I helped my wife into our car and rushed to the Vermont hospital. The evidence herein will prove my custody rights are maintained. 2 months later, Cassandra had been entered into the United States Citizenship and Immigration Services (USCIS) contracts since October 2016 by U.S. Immigration Attorney Mr. Kapoor as a U.S. citizen born abroad and contracted to accompany the mother back to the USA upon spouse visa approval. While both parents had contracted with the U.S. government for the return of the child to her country of origin since the month before birth, July 2016, followed by confirmation after birth, October 2016, afterwards, only one parent using false pretenses entered the child into contracts with Switzerland in March 2017. Contracts on the subject of matrimony with USCIS and contradicting illegal Swiss divorce proceedings ran parallel in the USA and Switzerland from March 2017 to January 2018, but the only state violating international laws and its own domestic laws has been Switzerland. Switzerland has never had jurisdiction on Cassandra Amina Prasad. Divorce is invalid due to breaches of international conventions. Since March 2017, Switzerland began breaching 34. Convention on Jurisdiction, Applicable Law, Recognition, Enforcement and Cooperation in Respect of Parental Responsibility and Measures for the Protection of Children 1, concluded October 19, 1996. Five, ongoing non-compliance of articles pertaining to protocols constitutes Switzerland's breach of the entire contract, but from the very beginning of divorce proceedings of March 2017, the following article in particular. Article 19. 1. The validity of a transaction entered into between a third party and another person who would be entitled to act as the child's legal representative under the law of the state where the transaction was concluded cannot be contested, and the third party cannot be held liable, on the sole ground that the other person was not entitled to act as the child's legal representative under the law designated by the provisions of this chapter, unless the third party knew or should have known that the parental responsibility was governed by the latter law. 2. The preceding paragraph applies only if the transaction was entered into between persons present on the territory of the same state. The validity of transaction, USCIS contracts for Cassandra, of 2016, by a third party, U.S. immigration attorney in the USA, and another person, Leila Jaksic and Devendra Prasad, who would be entitled to act as the child's legal representative under the state, USA, where the transaction was, initiated October 2016, concluded, December 5, 2017 spouse visa approved, cannot be contested. Even though embassies and consulates are located in another country, inside the building is legally considered territory of the country they represent. The host country does not have jurisdiction inside the embassy of a foreign country. After both parents had entered into contracts with USCIS and her U.S. immigration attorney in October 2016, Leila Jaksic and I brought our daughter, Cassandra Prasad, physically entered the U.S. territory of the U.S. Embassy in Bern on January 10, 2017 to finalize applications of October 2016 with the USA on behalf of KP, established custody by both parents, established U.S. citizenship through the father by birth abroad, applied for KP's U.S. passport, applied for KP's social security number, and for the agreement that Cassandra would temporarily stay in Switzerland pending spouse visa approval and contracted her return to the USA accompanied by both parents, Article 19:2 satisfied. The following X4 of business card and receipt indicates Ms. Madeleine Dupasquier of Embassy of the USA, American Citizen Service, Civil Services, verified KP's presence within the state territory where the transaction for Cassandra Prasad's U.S. citizenship was concluded on January 10, 2017 at 10:53 a.m., and provided proof of filings. The receipt reads as follows. U.S. Embassy, Bern, Switzerland, customer, Cassandra Prasad, date January 10, 2017, 10:53 and 51 seconds a.m., register, ACS cash, transaction, 1501819, tender, U.S. dollars, minor passport $20, PPT security $60, passport $25, report birth $100. All transactions are final. X4. Cassandra Amina Prasad's country of origin, conceived and made in the USA and contracted to return to the USA before she was born is confirmed by LJ's gynecologist, Dr. Ray Hermanjard, who prepared 2 letters upon LJ's request for proof of pregnancy in USCIS filings dated January and April 2016. KP having been conceived in the USA on November 22, 2015, LJ arrived in Switzerland on December 5, 2015, X5, on January 7, 2016, Dr. Hermanjard wrote, Declaration. The physician undersigned certified that Mrs. Prasad Jaksic Leila born May 21, 1992, is now 7-week pregnant. The term is due on August 31, 2016. Signed, Dr. Ayak Hermanjard. X6, on April 8, 2016, Dr. Hermanjard wrote, Medical Certificate. Mrs. Prasad Jaksic Leila, born May 21, 1992, domiciled in Veve. I hereby certify that the patient mentioned above had to leave the United States hastily for compelling family reasons. She is currently very isolated in Switzerland. As you have seen, she suffers considerable distance with her husband. Her current home is off-centered and, as a pregnant woman, this causes supply problems. She does not enjoy adequate nutrition. The term is due on September 30th, 2016. She had an injection of Pharinject 200 on February 9th, 2016, because she exhibited an iron deficiency. She also received folic acid and magnesium. Signed, Dr. A. Kermanjard. On December 5, 2017, LJ and KP entered the U.S. Embassy in Bern to conduct the spouse visa interview with the requirement that KP was present for the interview. Approximately 72 hours later, the spouse visa for LJ was approved, and issuance of an American passport for KP was post-mailed to LJ at our Fribourg residence. Including the fact that Cassandra was conceived in the USA, USCIS filings and petitions predate any legal proceedings in Switzerland, once again proving the child's country of origin and return is the USA. According to the Hague Convention on Civil Aspects of International Child Abduction, Chapter 4, KP is being wrongfully withheld in Switzerland for a breach of custody. CX7, LJ initiates USCIS contracts in July 2016. On July 26, 2016, LJ wrote, "Hi Mr. Kapoor. I'm forwarding to you the few missing information you needed from me. So first I'd like to confirm that my current address is Impasse de la Ploecha 3, 1700 Fribourg, Switzerland. About my previous addresses. 1. From January 2011 to August 2014. 2. From August 2014 to December 2015. In between I didn't have a stable residency, I was staying at various friends' house. 3. From July 2016 now. My mother was born in Belgrade, Serbia, and currently lives in La Tour de Pils, Switzerland. My previous employments. 1. From February 2011 to July 2016. 2. From May 2012 to July 2014, this was a seasonal job. 3. From August 2014 now. Thank you for letting me know if you have received the passport pictures I mailed to you about a week ago. Kind regards. Layla J. Persad." The validity of a transaction entered into between a third-party, U.S. immigration attorney, and both parents under the law of the USA state where the transaction, application form DS-260, was concluded, December 5, 2017, cannot be contested. Article 19-1, after Cassandra was born on August 16, 2016, LJ then sent the last required document, KP's birth certificate, to Kapoor Law Firm in New York in her email dated October 11, 2016. She stated, CX8. "Hi, this is Ms. Persad. I'm confirming that this is my email and it works perfectly fine. Please may you find attached the birth certificate from my daughter Cassandra. Do not hesitate to contact me for further information. Best regards, L." CX9, a copy of U.S. Department of State letter of LJ and KP's appointment for spouse visa interview, printed November 14, 2017, and scheduled within the U.S. Embassy, Bern, for December 5, 2017. The attorney instructed us that Cassandra absolutely had to accompany the mother to verify her presence for return as a U.S. citizen. LJ's father took them in his car to the U.S. Embassy early in the morning of December 5. Despite LJ had filed for divorce in Switzerland since March 2017, during the spouse visa interview she maintained statements of Devendra Prasad being her husband, maintained marriage, and permanent residence in the USA. Meanwhile in Switzerland, several civil proceedings took place without my knowledge since March 2017 to January 2018. LJ was pretending victim to the Swiss court that she was a domestic violence victim that fled the USA for her life. The father was absent from KP's life, and a pack of lies that will be dissected later herein, crimes of fraud in both states of the conventions. Shortly after the spouse visa interview of December 5, 2017, I was told over the phone by LJ's mother, Mrs. Tatyana Stenkov, that my wife was cheating on our marriage with another man for several months that was living in our Fribourg apartment and sleeping in the same bed. Disgusted and in disbelief, I asked LJ about the affair on December 17, 2017. To witness a loving wife turn into a vindictive opposite and threaten me, LJ said the words, "I can take Cassandra and disappear to Serbia," which is what made me initiate international protective measures with the U.S. Central Authority and Swiss Central Authority to prevent international abduction of my daughter to Serbia, where LJ's extramarital affair began. My daughter, that I had been having daily contact with via video communications and during my physical presence in Switzerland, although was supposed to be returning home, was now being wrongfully withheld from contact with me from Christmas 2017 until I arrived in Switzerland in August 2018, Cassandra's second birthday, to care for my daughter for 2 weeks. August 14, 2018, following LJ's non-compliance of Justice of Peace, Judge Gobet's orders to bring Cassandra to the SPJ, I hired a Swiss lawyer, Ms. Sophie Colai. My attorney nor I knew at this time that divorce proceedings began 17 months prior. Neither of us knew that secret civil proceedings, without my knowledge, were taking place and that the court failed to notify me and respect my right to contest the custody decision, while only taking the opinions of LJ to claim rights to my family and common residence in Fribourg. I must declare that all Swiss attorneys appointed by the court since 2017 to represent me, first of all, did not communicate with me in 2017, have no power of attorney to prove so, and falsely represented me in 2017. These attorneys never once informed me of my right to contest the divorce, and despite I mentioned that my wife and I were last living together in February 2017, 1 month prior to separation filing of March 2017, did not advise on the 2-year limitation of the separation filings, nor took legal action for the violation of my right to be legally notified of the commencement of the divorce case. Misrepresentation followed secret hearings and proceedings. Unlike the fraudulent claims made by LJ on the record that she had established a residence on her own, and the father was absent from KP's life, proof of our common residence is contained Exhibit 10, invoice from Livet Real Estate Management, dated December 12, 2017, when they billed Devendra Prasad for the late rent for Impasse de la Ploecha 3, 1700 Fribourg, Switzerland. 18. Convention on the Recognition of Divorces and Legal Separations. Concluded June 1, 1970, the Swiss court violated rights of respondent in separation and divorce. Article 4. Where there has been a cross-petition, a divorce or legal separation following upon the petition or cross-petition shall be recognized if either falls within the terms of Articles 2 or 3. Article 5. Where a legal separation complying with the terms of this convention has been converted into a divorce in the state of origin, the recognition of the divorce shall not be refused for the reason that the conditions stated in Articles 2 or 3 were no longer fulfilled at the time of the institution of the divorce proceedings. Article 6. Where the respondent has appeared in the proceedings, the authorities of the state in which recognition of a divorce or legal separation is sought shall be bound by the findings of fact on which jurisdiction was assumed. Article 8. If, in the light of all the circumstances, adequate steps were not taken to give notice of the proceedings for a divorce or legal separation to the respondent, or if he was not afforded a sufficient opportunity to present his case, the divorce or legal separation may be refused recognition. Having proven herein that the Swiss parties were having separation proceedings without my knowledge from March 2017 to February 2018, indeed, the only truth contained the March 20, 2018 decision is. In an email dated February 8, 2018, the Justice of the Peace sent to the Scenes Authority various documents indicating that the defendant had contacted the Social Action Service, as well as the Justice of the Peace, to which he reportedly stated that he was not aware of this proceeding, for violation of Article 4, denial of my right to be heard or cross-petition for an entire year, while the court based its findings solely on the petitioner's opinions. Therefore, a legal separation did not occur as referenced in Article 5, for the separation was filed days after my wife and I were living together at our habitual residence. Denied my right to appear or testify for all of 2017 by Swiss authorities that were lying on record of my involvement, therefore, falsified facts to unlawfully assume jurisdiction. Absolute violation of Article 8 is revealed from March 2017 to February 2018 as no part of international protocols of mutual assistance were respected to legally notify me of separation in Switzerland, for my refusal of recognition of divorce with a current U.S. marriage certificate, in effect since September 2, 2014. Switzerland violated Article 11 by violating Article 8, by recognizing remarry of Lejla Jaksic in Serbia in 2020 to commit polygamy. Had Switzerland respected Article 8, or notified me of proceeding, and I was given my right to cross-petition, a suspension of proceeding would have been requested as proceedings with the USCIS relating to the matrimonial status, spouse visa, pending the USA during 2017. Switzerland never had jurisdiction on Cassandra A. Prasad, divorce invalid due to breaches of Swiss Civil Code and attorney misrepresentation. With respect to Articles 5 and 11, the contracting state's Civil Code states, Swiss Civil Code, Article 114, a spouse may petition for divorce if, at the time the petition is filed or at the time the divorce request is replaced by a divorce petition, the spouses have lived apart for at least 2 years. Art. 117. One spouses may petition for a separation decree subject to the same requirements as apply to divorce. After having last lived together as normal man and wife at our common domicile in Fribourg from December 30, 2016 to February 27, 2017, DP exercising legal custody and parental responsibilities of Cassandra Prasad, LJ filed for separation the following week. 19 months later, she filed for divorce on September 13, 2017. Still unaware of secret civil proceedings in Switzerland, my wife and I lived together again as normal man and wife when I came to care for Cassandra from May 9, 2017, celebrated LJ's birthday on May 21 to May 31, 2017, when we last lived as a family. The civil courts falsified facts indicating that my wife and I had lived apart since December 2015 to justify separation filings of March 2017, would also prove disregard for the law. Her separation filings were admitted within 15 months of December 2015. CX3 and X4, passport evidence of my presence in Switzerland, and U.S. Embassy appointment requiring my presence, dated January 10, 2017. Divorce is invalid due to strategic denial of my right to be heard, fraud, and falsification of facts for erroneous conclusions, 2017 to 2018. February 2019, after 2 years of Swiss criminal activity of stealing my residence and withholding my daughter, I finally received from my attorney retained in August 2018, Ms. Sophie Coley, the previous 2 years of the multitude of correspondences, proceedings, hearings, statements, claims, and falsification of facts for erroneous conclusions. Basically, a pack of lies produced by Lejla Jaksic, facilitated by the court for 2017 to 2018. All documents still in non-compliance of international law for being in French and not translated to English, and still not valid to the state for the procedural law breaches. Despite my numerous requests to the FOJ's Mrs. Francine Hungerbuller and Judge Francois Xavier Ottergon, the Swiss have refused to provide me with a copy of the March 30, 2017 judicial decision. I have had to rely on parts of it that are referenced in the March 20, 2018 erroneous conclusion of Judge Francois Xavier Ottergon. The Swiss judge assigned a Swiss lawyer in 2017 to represent me that never contacted me. The lawyer, Mr. Konstantin Rufieks, was acting on his own behalf, pretending to represent Astromanov, my identity without my permission or conscious knowledge for all of 2017 according to the March 20, 2018 decision. Since March 2017, Layla Jaksic had lied to the court and all parties in Switzerland from the very initiation of the divorce filings of being a victim, single mother, falsely declaring all responsibilities of our daughter was her sole responsibility, while defaming my character in Switzerland. CX11, copy of tribunal decision dated March 20, 2018. G. In a letter dated 28 August 2017, Mr. Rufieks stated, in substance, that his client did not have the financial means to travel to Switzerland and sought the benefit of full legal assistance on his behalf. False, because I didn't know of Mr. Rufieks. H. By order of August 29, 2017, the President informed the parties that the hearing of 18 September 2017 was being held. False, because I was never informed of any hearings in 2017, for all the proceedings were taking place without my knowledge. J. By order of August 30, 2017, Devendra Prasad was excused from appearing at the hearing on September 18, 2017. The judge excused me from a hearing that was taking place without my knowledge. K. In a letter dated September 8, 2017, Master Rufieks reported that he had not heard from his principal, who would not have returned a signed proxy. Thus, in the absence of formal mandate, he explained that he was not able to file a response within the allotted time to do, making it look on record as if he was in communication with me, while in fact, Mr. Rufieks never sent me any documents in 2017 while the court was in non-compliance of 34 Convention on Jurisdiction, non-compliant of Hague Service, not contacting the central authority, and therefore, breaking procedural law by not legally informing me through international protocols of all proceedings and correspondences. All Swiss judicial decisions were being made solely on the opinions of the Swiss mother. N. In a letter dated December 5, 2017, Master Rufieks forwarded to the scene's authority a signed power of attorney, and requested an exemption from appearance in favor of the